Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing the particular situation of innocent absenteeism resulting in one's termination or otherwise being relieved from a job. So first of all, what is innocent absenteeism? Innocent absenteeism is a situation where an employee is absent from their job due to illness or disability, typically for an extended period of time. And over that period of time, a determination is made by the employer, often unilaterally, to say there is no longer the possibility of this particular employee returning back to work. And therefore, it is in our best interest, and it's only appropriate that we don't hold out any longer and we terminate this individual's position. Now, this always is a challenging situation for both sides, but one needs to look at some of the legal standards with respect to whether or not the employer sufficed in taking care of innocent absenteeism properly in advance of their termination. And first of all, what we need to look at is the principle from the Hydro-Quebec case as to whether the employer has met the determination for innocent absenteeism, which is 1, the employee's record of absenteeism is excessive, and 2, there is no reasonable likelihood that the employee's attendance will improve in the foreseeable future. So that is our starting point to ascertain whether the absenteeism, in the context of innocent absenteeism, is sufficient to move on to the next step. And even when they're terminating an individual, there are a number of points that the employer is typically sought to address in this context. And some of those are the following. Was the employee provided with an appropriate warning that their employment was in jeopardy for innocent absenteeism or any other reason? Did the employer initiate a process to consider accommodation of the employee's disabilities? Did the employer invite or involve the employee to participate in an individualized assessment of their circumstances, disabilities, and possible accommodations? Did the employer involve the employee in the decision-making process respecting the termination of their employment before terminating the employee? And did the employer take any steps to accommodate the employee before his termination for innocent absenteeism? So as you can see, there's a lot of procedural steps that are expected by the court system, by the legal system, with respect to effectuating termination for innocent absenteeism. And given the degree of steps, the significance of this, it's critical that the employer follow through on taking enough steps and not simply say, the record shows this, they're not getting better, we're just simply going to terminate them. They have to have involved yourself appropriately. And when they haven't, or when it seems insufficient, then legal issues can arise surrounding innocent absenteeism in the context of an inappropriate termination from one's position after one's been spending a considerable amount of time suffering from illness or disability and away from their job. And in those circumstances, it is always advisable to seek out the input of knowledgeable legal counsel to determine what steps, if any, should be taken and how best to proceed with the given situation that is created by one's termination from one's former employer. Thank you.